just starting class. It's on? Yeah, let me stand next to you.
Well, I'm sort of here. Well, I just came back from China. I'm supposed to go to the US. Again, the interesting one. Okay.
Hi guys, welcome back to Future Law Day 2. Today we have a couple of outstanding speakers, but before we want to get into the actual discussion, the interaction, I want to introduce one other member of the teaching community and this community, Professor Sandy Pentland.
Hi. Hello, everybody. So, welcome. We just got back from China, so I'm not entirely rational or here, and I'm probably not going to be able to stay the whole class because I'm going to actually have to go take a nap. My apologies. But it's really exciting to see this happen. Looking forward to all the things that happen. So please don't take it as anything negative if I disappear.
I won't take it.
Well, actually, if I start snoring, you won't like it. So, great. Thanks.
Thank you. So today we have two terrific speakers on a topic that should be near and dear to all of us. Artificial intelligence and its role in law, the productization of AI, and the way that it's going to change the legal future. And I want to just briefly introduce our two speakers, but before I do that, I want to thank one of them in particular, Brian Kuhn, who's from IBM, and Des is just going to talk for a second about an event involving IBM.
Thanks. It is very fortuitous that Brian should be here because IBM Watson for Law is one of our collaborators for the MIT Legal Forum event on October 30th and 31st that I mentioned last class here on the 6th floor, where we'll be doing a deep dive into law and AI and law and blockchain. So thank you for partnering on that.
Thank you for the privilege.
What can we look forward to at a high level?
Understanding a rational approach to use case identification and delivering value rather than, hey, I want to do something with AI. Practical, rational approach to deliver business value. And also change management. We'll discuss that a great deal. And we'll focus a lot about on the intersection of blockchain for law and AI for law. Because these have been presented as two separate pretty equal monoliths really until recently. And of course they're not. Touch a little bit upon that today too.
There's a computational overlay, and some of your projects I think will touch on it too. All right, well, thanks very much for that. And on with our regular programming.
All right, thanks. So I'm back in MC role here. So here's what we're going to do. Today we're going to have two speakers, and what we're going to do is we're going to have them speak back to back. They've both flown from across the country to be with us today, and I want to just give a very, very brief intro to both of them before I turn it over and let them say the really interesting stuff. So our first speaker today will be Pablo Arredondo. Pablo is the Vice President of CaseText. CaseText is a legal research tool that uses artificial intelligence to do some really remarkable things. Back in my day job at Suffolk Law, I've taught legal research and writing for a decade. What they're doing at CaseText absolutely changes the dynamic of how legal research is done in a way that these multi-billion-dollar companies just can't keep up with. So I'm really interested for you guys to interact with Pablo and to hear a bit about his insights into AI and the work of CaseText. After that, Pablo is going to join us in the audience, and Brian Kuhn from IBM is going to step up. Brian is the co-founder of IBM Watson's legal group. He's done remarkable things. He speaks all around the world on the use of AI in the legal industry, and he's got some projects underway that are going to change things in a major way, including a project and a use case that he personally headed up that I hope they'll say a few words about. So after Pablo and Brian have both had a chance to talk, we'll invite everyone to join the conversation and think together about how their work might map onto your work and the ideas that you might have, and we'll get their feedback. So without anything further, Brian and Pablo, thanks for being with us, and let me hand it to you, Pablo.
All right, thank you very much, Gabe, and thank you all. What a true honor to get to be here at MIT to talk about artificial intelligence in the law. Let me preface this by saying that when it comes to artificial intelligence, you guys are a stone throw away from the folks that are creating much of it and have built much of it. And so, while I'm happy to talk about some of the issues in legal informatics and some of the things that are nuances for law, I would be remiss if I did not let you know that when it comes to pure, real, hardcore AI, certainly you would want to get input from better men and women than I. But the truth is that law is a field where AI can have a lot of implication. A little bit about myself. So I graduated from law school in 2005, and I worked as a patent litigator at a firm in San Francisco and then a firm in New York. And I realized there was a discrepancy between the tools. We were representing companies like Apple and Google, and we were fighting over their technology. And the technology that we were using to do it was terrible, right? And so I noticed that there was this disconnect. Now, the partners at the firm, you won't be surprised to know, were not overly concerned with my thoughts about our technology that we were using. But I found that there was a place where they do care about these things, and that was the Stanford Center for Legal Informatics, also known as Stanford Codex. And Codex basically has one foot in the computer science department at Stanford and one in the law school. And I've been there sort of putting my shoulder towards building better legal technology, and in particular focusing on legal research. Because legal research is a crucial aspect in law. In fact, it's not just a tool of law. Legal research is, in essence, the practice of law, right? Finding the right precedent among the 8 million or so judicial opinions that are out there is one of the key skills that you learn in law school. It's one of the mandatory classes that you have to take. And depending on the firm you're at, you can spend up to 30 to 50% of your time as a first year doing it. And it's one of these situations where it reminds me of this Jim Morrison line, the song. He says, "I've been down so long that it looks like up to me." And I think with law a little bit, you have folks that are they're so used to these tools, Westlaw and Lexis, and they sort of think that everything's going swimmingly. And that's all well and good until anyone stops to actually look at it. And then you find, in fact, that these long Boolean queries that they're writing, right, these long strings that they create to try to convey context, are both over and under inclusive. They're getting results they didn't want, which makes them inefficient and sometimes miss cases. And they're missing cases that they did want, which of course makes them miss cases. And part of the problem, I think, is that these traditional systems are basically relying on a form of the wisdom of the crowd, which is to say that they'll tend to put at the top of your results the cases that have been cited by a lot of other cases, right? And we've seen how well that works with the internet, right? Who could argue with the wisdom of the crowd? The problem, though, when you try to apply that to professional search, is that your context is as unique as your client, right? So imagine if you went to the doctor's office and said, "Oh, I kind of have a headache," and he said, "You know what, this is our best-selling pill, just take it," right? You'd say, "No, doctor, I don't care. I want what's best for me," right? And so these tools then that rely on the sort of wisdom of the crowd that try to do this generic one-size-fits-all systems, invariably, they're sort of good for showing you the big seminal cases sometimes, but they're very bad at finding that needle in the haystack. So then the question is, okay, well, if there's not the wisdom of the crowd, then what wisdom might we use, right? And so you might think, well, let's just use the wisdom of the user, right? This is a patent lawyer we've seen. Normally, he tends to go to patent cases, right? But then the problem with that is that you can have a violent shift in your context. So I would be doing patent litigation, and then suddenly I would be doing a pro bono immigration case. And so believe me, when you're doing pro bono immigration, patent law is very rarely brought in. Like there's never IP issues. I wish I would ask, do you have any patent? No, you don't. Okay, well, we'll fight to keep you here. And so the wisdom of the user doesn't quite work, right? And then also if you were doing biotech versus computer science, it doesn't even have to be that big a shift. If you were doing a semiconductor patent, you don't want to see the same cases if you were doing a gene patent. And so what I realized very early on in my sort of efforts here is that there is the correct wisdom out there. And that wisdom is the wisdom of the litigation record itself that's specific to that matter. So when I file a lawsuit, I file a complaint and it's in digitized format. And that begins a very long string of data that encodes a context. Just as real as our genomes encode a biological organism, this record encodes who the parties are, what the jurisdiction is, what the underlying facts are, and it grows as the litigation progresses. And once you couple a litigation research system to that record, you can have amazingly intuitive results, and sort of things open up which just weren't possible when you were ignoring that record. So when I first thought of this, it was in terms of, okay, well, you know, I'm going to do a search for damages, and it's going to know by looking at the complaint that I don't want antitrust damages, I don't want tort, you know, slip on a banana, I want my patent damages, right? But then when we built the prototype, something else occurred to us, which is like, you don't need the keyword actually, right? Because once you're listening to the litigation record, before you type a thing, the software starts to say, no, I've got an idea of what you might want to read, right? And so here we are with Kara. So let me show an example here. I used to be able to say, this is a brief from the Uber litigation, but now they're being sued so much that I have to tell you which Uber litigation I mean. So Uber drivers brought a class action lawsuit saying that we should be considered employees, not independent contractors. And therefore you owe us gas money. Understandably, Uber said, you know, we'd prefer that that not be the case, right? And so there was a big litigation. For those of you that are lawyers, this will make, you know, you've seen this a million times. For those of you who aren't, this is basically a long, you know, 30-page document that the lawyers for Uber filed telling the judge, I don't want to go to trial. We don't need a trial. The jury's not, don't even involve them, right? There's no real issue. And so true to a common law system like ours, you know, this table of authorities are all of the earlier decisions that they're citing. Because that's how we argue things in our system, right? We look at all the earlier cases and all the earlier opinions. And so you can think of that as just a very complex network of unidirectional citation, right? They don't cite back and forth because they, you know, have to cite back in time. And then a bunch of text, right? A bunch of words where they fight and fight. And we haven't doctored this in any way, right? So traditionally what would happen, and what is happening all over the country right now for the, you know, 95% of attorneys who don't have us yet, is they read this brief and then they try to write their long Boolean query, you know, independent contractor and driver and chauffeur, and, you know, and they try to guess at what the right words are, and they're always getting it right or wrong. This is what you do with Kara.
It's a raw brief.
Raw brief, no metadata.
OCR.
It'll take a second longer if you have the OCR, but we'll wait. And it returns cases that are not in the brief, and that's key. It doesn't return the cases that you already have. It says these are cases not in the brief. So we'll scroll through a few. This first one is about whether or not drivers are independent contractors. Again here, whether classic drivers were employees. It turns out FedEx drivers brought the same claim a while back. Actually, they tried twice, you know, poor guys. Bus drivers at a terminal, and then number 6, my favorite, holding whether Lyft drivers were employees or independent contractors was a matter for injury. What it brings you then is case law that's related to what you're working on, not just legally, but factually, right? And we've designed it from the ground up to find the things that you might miss using traditional tools. And since this is MIT, we're gonna get deep in the weeds on this because we're here. All right. How many of you guys know about Shepard's or Keysight? Those of you who are law students know about this. Okay, so one of the big tools that lawyers use is a tool that lets you follow that direct citation path that I mentioned. So you're saying, I'm reading this case, which cases cite to it directly, and I'm gonna walk that path, right? But now think about a different situation. Imagine a case that doesn't cite directly to another case, but you see those two cases together a lot in paragraphs, right? Just like you see Friday the 13th and Nightmare on Elm Street on the same shelf, even though they don't talk to each other. I mean, by the sequels, they might have actually started to talk about each other, but those early ones, right? That proximity, that co-reference to each other is a very important relationship, because what that means is that a judge read both those cases and said, I know they're related even though they don't cite to each other, and that's why I'm gonna talk to them, you know, to each other. And so that's one of the things that we do, is we use that important relationship. And if there's a theme to all of the work that I've been doing over the last 8 years, it's that where judges have put in a lot of effort to do something, harness it, right? Information is work, right? Choosing among many things, choosing one and selecting that is information. And there's always work there, and it can almost always be extracted, especially in legal documents where you tend to have uniform patterns. All right, let's see. So now we also do suggested terms. So where this matters, I'm only gonna bring this up because the core technology we're using here was built with genetic algorithms. So how many of you guys have heard of genetic algorithms? Cool. I'm beginning to sense lawyer versus non-lawyer here as I do that. So, you know, neural nets get a lot of play, you know, and everyone kind of talks about neural nets, but I think genetic algorithms are the coolest thing, right? So what these genetic algorithms do is we're mimicking not the structure of neurons, but the process of natural selection, the very thing that led to our beautiful neural nets, right, over millions of years. And so what you do is you basically tell the algorithms, in plural, like you have a little population of them, and you say, okay, kiddies, like, you know, success is to have a high score at Mario Brothers. That's what success means. Now go. And they all try their best, and then you literally take the two that do the best, and you say, well, why don't you guys sort of mate and produce a new group? And you literally just replicate that over and over and over and sort of optimize it, right? And again, this is something that there are people here that will tell you about it, probably people who invented it. I wouldn't be surprised to learn, you know, a stone's throw away from here. But genetic algorithms is just one of the many types in the AI family of algorithms that you can then use to sort of start to make things more intuitive. All right, so how am I doing on time? So I think what I want to show you, let me see if this opens correctly. Let's see, can I say this? So this article in Stanford Law Review talks a lot about the different aspects of artificial intelligence in law. And it was written in 1970. And half of the paragraphs in this thing could be things that I could say to you today and sound like I'm in sort of the zeitgeist of people talking about law and artificial intelligence, right? What seems cutting edge to us right now are actually things that I think are decades old often, right? And the same sort of issues that this guy brings up. Can a computer do analogous reasoning? No, right now, right? You know, will computers replace lawyers, things like that, right? So all of the conversations that we're having right now have actually been occurring off and on, I think, for decades. And so I think one of the other things I'd advise you guys when you look at this space, don't be afraid to go look at what people were saying in the 80s or the 70s, or, you know, the 90s even, right? So just try to, you know, talk about this stuff because you'll see a lot of it's pertinent and can actually help inform your thinking about these. And the problems that existed in the 70s that are still here are obviously thorny ones that if you solve, you'll probably be well off. All right, so I think lastly, I want to show you, all right. So how do I know that this is the holding of the split case? Right?
Pablo, could you define holding for folks that don't know?
Sure, actually, good point. Okay, so in a case, the judge will talk about a lot of things. He'll talk about the background facts, he'll talk about the overriding test, he'll talk about all these things, and then he'll make a holding, which is sort of the core legal point that he wants to be taken away from the case, right? It's sort of one of the key decisions that's being made. And very often you'll say to somebody, you know, just tell me what the holding of the case is. Or in court, you'll say, Your Honor, this case held that, yada, 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 right? And the problem is that there's no AI out there that you can feed a case and it will spit out the holding for you, right? Then this, you know, IBM Watson confirms this, right? So, you know. So what we had to do, we had to realize that if there's no AI out there that does it, so what Westlaw and Lexis, these big companies do, is they hire an army of editors. And these editors may or may not love their jobs, right? But they're out there churning out these little summaries, right? Writing sort of one-size-fits-all summary. But what we realized is that there's another place to get concise summaries. Let's see, let's find one of these. Let's find the left one. And that's in these special things that are unique to law called explanatory parentheticals. I mean, parentheticals aren't unique to law, but what is unique to law is that very often, I mean, I'll tell you exactly how many times in a second, but judges will cite to a case and then in a parenthetical give you the summary. And because of this thing called the Blue Book, which is a uniform system of citation, which I hated in law school, right? It's every stupid comma and period and dash that you have to do, and you have to capitalize it. It's this. But boy, when you get into legal informatics, do you love the Blue Book. Because the Blue Book is what lets the regular expressions, right? And then people get mad at me like, oh, we should be doing Python parsing grammar. Nah, I like the old school regular expressions that you just find for this. So you can write regular expressions that say, pull out any parenthetical that follows this specific case site. And, you know, and at first I just pulled out ones that began with holding. But then I was like, what about finding? You know, finding is a good word, or concluding. And then I started to just get endorphins every time I pulled out more. So I just pulled out everything that wasn't quoting. So I pulled out 400,000 of these summaries. And then our VP of data science did one of these sort of like, you know, step aside, young man, let me show you what this is supposed to look like. And then he pulled out 2.3 million of them. So think about that for a second. That's 2.3 million summaries written by judges, right? I mean, talk about having a good editorial board. And it was there this whole time, just waiting, just saying, please, just take me, I'm here, right? Because judges had done the work, there was an identifiable pattern, and we pulled them out. And so now I submit Westlaw and Lexis, even though they had, you know, ours is the crown jewel of case summaries, right? And in fact, you'll see multiple summaries because different courts will summarize the case looking at it from different angles. Actually, no, those are key passages. Sorry, I need to go back to one with summaries. This case is too new. That's the one downside with it. Different cases will look at it from different angles. And sometimes, depending on your context, one of those sub-angles is actually what you're interested in, right? So it's kind of in a sense free, and it's more powerful, and it's from a more reliable source. So I guess what I want to stress there is that where AI can't take you, it doesn't mean you give up, right? It means, are there places where humans have done that work in a way that can be reliable, right? And that also goes for creating training sets to do sort of sophisticated machine learning stuff, right? So one of the big problems is we don't have a citator that's editorial, right? So we can't tell you this case was distinguished by this case, right? Again, Westlaw and Lexis, army of editors, just reading and saying, I think this distinguishes it, right? And they disagree with each other 15% of the time, so it's not like they're perfect, right? But a lot of these parentheticals don't begin with the word holding, they begin with the word distinguishing. So it'll say, John B. Doe, paren, distinguishing, Penguin v. Tiger, or whatever, right?
Could you maybe just define distinguishing, because it's not the Merriam-Webster definition here.
It's not that different from Merriam-Webster. So yeah, you're right. It's distinguishing is what the court is saying. It's not that I find this case to be bad law. It's that it doesn't apply here for various reasons of the fact. So I cite a case that says, Your Honor, it says here you need a warrant to board the guy's, Uber. And they say, well, he did have a warrant, so that doesn't have anything to do with this. And you go, oh, sorry, right? And that's where you want that citator so you don't look stupid like that, right? But my point is, I guess, that you can also use the judge's descriptions of cases as though you would hire them to do your machine learning labeling, right? As though they had been hired to kind of create the training sets that you can use. And then you can then feed that through and come up with algorithms that can then, at least to varying degrees of confidence, tell you, I think this relationship is distinguishing or not. So those are sort of some of the things that we're working on and sort of looking at doing this. And the last thing I would say about this is right now, the interface is drag and drop. But the nature of our court system is that when you file a brief, it's filed publicly. And so we're now starting to listen to thousands of dockets automatically. And as soon as something's filed, running it through our tools and sending it to the attorney. So the attorney gets a note from the court that says, this was filed, and then 2 minutes later, we're in their face being like, and you should read these cases about it, by the way, right? And we have confused a lot of attorneys like that. So, but I see a system where we're going forward, and this can also help for pro se, for folks that, are trying to represent themselves, for folks that have, can't afford an attorney that can hire 3 associates to do research. This ability to use the litigation record itself to retrieve useful case law, to sort of assemble these things, I submit to you guys is going to be sort of the future of how law is practiced. Thank you so much for having me.
Thanks, Pablo. So please hold your questions for Pablo. I'm sure people have them, as do I. We're going to welcome Brian Kuhn up next. And while Brian comes on up the lectern, let me just say a couple of words about Brian. Brian is the person who created the co-founded IBM Watson Legal Group. And he is also a proud alumnus of Suffolk University Law School. And he's going to present today some of the work that IBM has been working on in the legal space using Watson.
Just 1 second.
Shit is different. Yeah. No problem.
No, it's okay. I have. CGI. That's mine. Sorry.
Yeah. Okay. And we'll be right back.